SJC-13702, Branda Peebles et al. Versus JRK Property Holdings, Inc. et al.
Okay, Attorney Sachs.
May it please the court. Good morning, Your Honors. My name is Keith Sachs, and I represent Branda Peebles and Joshua Berger and the putative class in this matter. First, I'd like to make a quick thank you to all the amici who filed briefs in this matter, and good morning to my brother and sister. Before you today are two questions certified by Judge Gorton from the federal court, and those questions need to be discussed and answered within the context of a couple things. Attorney General Campbell's concern that the current status of the law makes it ripe for error and abuse, and also the industry standards within the landlord industry, which is landlords generally will clean and should paint or maybe paint their units prior to rental. So the answer to the question, the first question, is very simple, because it almost answers itself by using the word refurbishment. Refurbishment means to freshen up, to spruce up. So the answer is simple. If a fresh coat of paint or professional cleaning remedies whatever the issue is, then we're talking about reasonable wear and tear. It's very simple.
Well, it really isn't that simple, is it? It's so fact specific. Yeah. So how can it, I mean, and refurbish, you know, someone's definition of refurbish is going to be different from someone else's. So I don't see the first question as being simple. I see it as being highly fact specific.
Well, I don't see it being highly fact specific when we're talking about cleaning, because the statute talks about damages, right? When we're talking about damage, we're talking about physical injury to property.
Well, cleaning can be all different kinds of things too, right? Yeah. I mean, you can have a total pigsty versus you can have, you know, minor, you know, vacuuming and cleaning up, right?
Well, sure, but that's when you get to, when you're talking about something other than a professional cleaning and a simple coat of paint, right? Then you can get to the extremes that the appellees talk about, right?
May I ask you a question?
Yes, sorry.
What, in your view, is the difference between refurbishment and housekeeping?
Well, housekeeping, I would say, is a general day-to-day cleaning. Refurbishment would be sprucing up, painting, redecorating, maybe, things like that, but not anything that relates to physical damage.
Well, but I'm looking at the actual certified question.
Yep.
So he says there's nothing about cleaning. It says painting, carpet repair, or similar refurbishment. Do you think the or similar refurbishment relates back to both painting and carpet repair?
I do, Your Honor. I'm reading it as such, that he's looking at it as refurbishment, whether it's, and I know he uses the word repair, you know, to modify carpet.
Right, so it's not carpet cleaning, it's carpet repair.
Yeah, and if it's repair, I agree, right? That is something that's beyond reasonable wear and tear. Repair would, if we were talking about cutting out large swatches of carpet to repair things like my brother argues, using the carpet as an ashtray, yes, that's unreasonable conduct by a tenant.
But see, given that example that you just articulated, which I think is a good one, aren't you actually saying that it's very fact-specific? I mean, to Justice Kafker's point, it's not that these issues are rocket science, it's just that they depend on the facts of the case.
Yeah, and I agree. They become fact-specific if we're going beyond just a general professional cleaning and painting, something that every landlord should do when they're reletting an apartment.
I'm sorry, a general professional cleaning?
Yes.
That is what? That's reasonable wear and tear? Or
yes, absolutely. Mm-hmm. Absolutely, because the landlord has the economic interest.
What does professional cleaning entail in your estimation?
Well, I would say that a professional cleaning, I think it's just someone who's in the profession of cleaning.
So anybody who comes in weekly to clean, that's a professional cleaning?
If that's how they make their living, they're professional cleaners.
So the terms of the lease depend on how a third party defines cleaning?
No, I think you can use the word professional, or you can use the word cleaning in and of itself. But if you're charging someone to simply clean an apartment, that is a violation of the statute, because that is not.
Well, now
damages.
you're on to question 2.
Well, question 2 deals with a lease provision that puts the onus on the tenants, which in this particular case certainly does, right? It says you must do a professional cleaning, you must do a carpet cleaning, or you will be charged, right? And if we're talking about cleaning, not damages, that addendum puts an onus on the tenant to do what the landlord should be doing to re-let their property.
Can I go back to question 1 for a minute?
Sure.
What I heard you say was that general professional cleaning or painting can't be charged back to the client. I'm trying to connect that to the first certified question, and I think that if we were to accept your formulation, we would answer the first question no. Is that correct? Because that's not what Judge Gordon has asked us. Judge Gordon has asked whether painting, carpet repair, or similar refurbishment. And I didn't hear those 3 things in your formulation for what should be encompassed by the statute.
Yeah, well, I'm looking at it from the word refurbishment. And like I said before, I know he uses the word carpet repair, but refurbishment should mean simple things like cleaning and touch-up painting, whatever that may be. Because those are not things that are damages, right? And I think that gets to the Attorney General's point about why there's been so much error and abuse in this, right? This is very simple. For a landlord to go in and do these very inexpensive issues like carpet cleaning, general cleaning, and touch-up painting, that's in their economic interest to do that.
There's a second sentence too, right? So you not only look at the first sentence, but the second sentence of the statute requires a detailed breakdown, right?
Yes.
So doesn't that, again, make it more fact-specific? Even, like, some cleaning, yes, some refurbishment, no. I mean, it's going to be in that specific response, too, that we're going to get more detail, aren't we?
Yeah, and I understand that, Your Honor. And that's my point, is that what I'm saying is these very simple things. If you can just go in and do a general cleaning or touch-up painting, then that's reasonable wear and tear. If you are dealing with things that aren't satisfied or remedied by simple professional cleaning or touch-up painting, then we get into the factual issue
But
and
aren't you
put the landlord to their proof.
just trading different words for painting, carpet repair, and similar refurbishment? What is touch-up painting?
Well, touch-up painting is just light painting that there may be a small mark on a wall or something like that.
Okay,
you
so
know?
fact-specific.
Well,
What
touch-up
about,
painting.
you had previously said something about physical damage to property.
Yeah.
What if you nail something into the wall that's physically damaging the wall? Is that reasonable wear and tear?
Well, if it's physically damaging the wall, meaning there's a giant hole in the wall, that is damage. That's beyond reasonable wear and tear.
So you make a giant hole in the wall when you nail something to hang up a photo?
I'm saying.
Okay, so
if
I'm
you-
talking about those nails
Yeah,
that
those-
one puts in the wall to hang up photos.
Yeah, that's completely reasonable wear and tear.
Okay, so but if it's bigger, how much bigger does it have to be to fall outside of reasonable wear and tear?
I think it has to be anything bigger than what you would reasonably use to hang a picture.
Well, how about if we have an artist living there and they put up 200 of their paintings? There are little holes in each of them, but there are 200 of them. Is that reasonable wear and tear, or is that unusual and covers? So we have to, again, get into the detailed facts of something.
Well, no, I don't think you have to get the detailed facts. I think.
Okay, so if I put up, I'm an artist, and I put up 300 paintings in my house. And the whole wall is, when I leave, the whole wall is filled with those little divots. Is that reasonable wear and tear?
In that context, if the landlord knows he or she is renting to an artist who's going to be hanging painting, sure.
But then it becomes fact-specific again.
Well, yes, but those are the situations that can be dealt with per the statute.
Okay, can I move you to this? I think the second question is actually much harder.
Yes.
Could you address the second question then? And one part of your answer, could you address, it doesn't specifically reference the security deposit. And you complimented the amicus briefs, but the Greater Boston amicus brief says that you can have such a provision as long as you don't take it out of the security deposit. So, right?
Well, sure, this statute deals with the security deposit, right?
But the statute does, but the provision that you're relying on, it may be applied to the security deposit, but it doesn't refer to it directly, right?
The statute or the addendum, I'm sorry, Your Honor.
The provision you're objecting to in the lease.
Yes.
Does not say it's going to be deducted from the security deposit. They actually, at least one of them, they do deduct it from them, but it doesn't say it, right?
Well, Your Honor, you're right. They did actually do it in this case. But the addendum does say it because it uses the word applied. Charges will be applied. There's nothing else to apply charges to, Your Honor.
Well, Greater Boston, again, you like the amicus brief. They say you can bring a separate breach of contract action. I don't know if that's realistic in this world, but they say there is another vehicle to enforce these things, and they should be legal if you use the other vehicle.
Yeah, and that vehicle, to the extent there's a breach of contract, right, for an issue that is outside of the security deposit, then fine.
Is the issue that it leverages the security deposit as opposed to violates the security deposit statute?
Well, it violates the security deposit statute on its face by saying you need to do these things or charges will be applied. They will be applied to nothing else other than your security deposit. And if you look at the SOTA exhibit, sorry, page 75 of the first appendix, what does it say? Charges applied, right? That's the language they use.
There's also,
no other
sorry,
way.
can I interrupt? There's also language, if you look at Joint Appendix 49, the part of the actual lease, not the addendum,
Yes,
that
paragraph
says,
35 of the lease.
paragraph 35 says that if you don't clean adequately, you'll be liable for reasonable cleaning charges which shall be deemed property damage. And then 2 paragraphs later, when talking explicitly about the security deposit, it says you'll be liable for, so same phrasing, the following charges, damages beyond normal wear and tear. So I have 2 questions for you. So I think your argument depends on reading this, that the word damages, shall be deemed property damage. Do you think that that is subject to, in paragraph 37, it going beyond normal wear and tear, or not subject to?
Well, certainly if they're deeming it property damage on its face, then they're trying to say that it's beyond reasonable wear and tear, right?
And then, so I have a second question for you, which is, you have relied a lot on 15B8 for the proposition that this is not enforceable, but you haven't really briefed 14B6.
Yeah,
And so could you just address
Yeah.
whether the question specifically, whether this amounts not just to a provision that's unenforceable under 15B, but that is actually seeking to obtain a waiver of the provisions?
Yes, Your Honor. And as I was preparing for this, I realized that we maybe have focused differently, but it's 15B6 is the issue. 15B6C says you can't have a provision in your lease that conflicts with this section, right? And that's what this addendum does, right? It preemptively seeks to have tenants on their own go out and spend their own money to professionally clean and carpet clean to cover the landlord's costs, right? And they do this by saying, if you don't do it, we're gonna apply it. We're gonna apply it to your security deposit. There's no other way to read that, right? So that in and of itself is a violation. And it's certainly a violation because it doesn't say that you're not responsible for reasonable wear and tear.
What
Right?
if they,
It just
what,
says-
what if they just charged the tenants for the amounts that are in the addendum and they didn't take it from the security deposit?
Well, if they don't, well, I guess at that point, if they're not taking it from the security deposit, they're not violating the security deposit law. What they're doing is somehow saying, okay, we're going to charge you, but then they would have to go and sue them
Right.
for that. That's that's an issue that if it happens, it happens. But what we're focused on here is the security deposit statute. If they think they have a claim for a violation of a lease term, a breach of a lease, that's different, right? But
I guess my question is, because the addendum doesn't mention the security deposit, this is just a thought experiment. If they didn't take it from the security deposit and tried to get it another way,
well,
would there be an issue?
if they tried to get, no, because I don't think that would be if they're not taking it directly from the security deposit, right? They're not violating the
Then there's
security-
no issue with the addendum.
Well, there may be an issue in terms of that doesn't make sense to bring those kind of things to the court, but it's not a violation of the security deposit statute. But we know here.
Why? Isn't it just an end run around the security deposit statute?
Well, certainly the issue with the money that's in the security deposit, that's what the statute applies to, right? And also, I haven't thought about it in great depth in terms of having these separate contract issues, right? But the security deposit statute deals directly with money in the security deposit and reasonable wear and tear. And don't forget that the security deposit statute also
I guess I was
allows-
trying to ask you a friendly question. If somebody goes after a tenant for breach of contract, instead of self-help and using the security deposit that was given to the landlord at the beginning of the lease, isn't it effectively going around the Security Deposit Act?
Well, yes, it's effective.
Yeah, so it would actually fall within the provisions of Section 6 or Section 8 as an end run around the security deposit law.
Well, if they're trying to get the money through other means other than the security deposit to do an end
The
run, then
money
yes.
is coming from the tenant,
Yes.
no matter what.
Yes.
So
if they-
here's $100 back. By the way, you owe me $180 for the professional cleaning. Isn't it the same?
Well, it is the same, but it's a different type of egregious behavior,
Well, but
right?
it's not the same though, right? Because the security deposit, you've got all kinds of super penalties associated with playing with the security deposit. And it's readily available to the landlord. They can just, they can take the money out easily. Bringing a breach of contract case, you got to hire someone like you or him. They cost money that never happens.
Yeah, no, I understand that. And that's why I don't think it makes sense that that would ever actually happen, but I do see the point of it being an end run around the security deposit statute. And that's the problem as it relates to the security deposit issue and damages versus reasonable wear and tear, right? Is that it's too easy for a landlord just to take it, right? They can just do it. And that's, why this addendum is particularly egregious, because they did do it, certainly in this case.
But it's weird though, because they don't do it from, you have two clients here. One they take it from, one they don't, neither professionally cleaned, right? So there's another step in what they do. Now, it may be because they're in a position of power, that other step, they have too much power, but it's different. They don't take it just because of not professionally cleaning based on the facts we have here.
What we have before us right now, we probably don't know the answer to that question, other than they did take it from Ms. Peebles, but they didn't take it from Mr. Berger.
So what do we make of that?
So what we make of that is that if we get to the point where we get a class certified, then we'll get the discovery that shows what they actually did.
But we have to give some guidance to the federal court on the answer to the second question. And I'm just not sure what guidance we're going to give if we don't buy into your view here.
Well, I think in terms of, if you're talking about is the addendum a violation of the statute, I think that's answerable on many levels, right? That it preemptively.
But isn't the answer it may, depending on the factual circumstances?
Well, no, because it doesn't have to be enforced specifically to be a violation, right? And I think this issue came up very slightly in the Fleming case, where the court talked about,
But how can we answer the question the way you want, which is, it is a violation when one of the two tenants here, they don't deduct it. Two, the provision doesn't expressly state that the money has to come out of the security deposit. Don't we have to give a much more nuanced answer to the federal court?
no, I think the answer, and I do think it says it comes out of the security deposit by using the word applied. It's the only thing that it can be applied to.
Based on what Justice Stewar's formulation, you're adopting that? Is that what you're saying? That's how you get there?
What I'm saying is getting to the answer that the addendum violates the statute is that, first of all, it definitely says it's applied, which means it comes out of the security deposit. Certainly it violates it from the standpoint it doesn't say that you don't have to pay for reasonable wear and tear. It also violates it because it's essentially acting as a waiver of the right to not pay for reasonable wear and tear, right? And there's no other way to look at this other than they are going to charge for reasonable wear and tear if you don't do this professional cleaning, right? So the answer to the case as it relates to Peebles specifically, in this case, right, it was applied and that was wrong. And I do think that as it relates to the addendum in the abstract, it certainly has the potential for influencing tenants to do something that the law does not require them to do. And that would be a violation.
All right. Thank you.
Thank you, Your Honor.
Attorney Wintner.
Thank you, Chief Justice Budd, members of the court. My name is Tom Wintner on behalf of the appellees. I think I'll start with question 2 rather than question 1 because I do agree that's the more, I think it's the trickier question, and I think the answer is a little bit more nuanced with respect to that. And I think I'll start from the premise that security deposit, the security deposit is different. So money that's in a security deposit for the benefit, which is in fact the tenant's money, is different from any other money. And that kind of goes to the question that was posed earlier with respect to the difference between taking a deduction from the security deposit on account of X, Y, or Z, and subsequently or separately bringing an action outside of the security deposit. And to me, the answer comes in that sort of 15b-8 clause. So 15b-8, I see that as a provision. It's kind of like the security deposit supremacy clause. It basically says, look, nothing, you can't contract around the security deposit. You can't use the lease to contract around it. You can't use some other way to contract around the provisions of the security deposit. And that makes sense because the security deposit statute is this very articulated, reticulated provision.
Are you leveraging the security deposit? So if I'm a well-meaning tenant and I read this and I read the lease and it says, boy, I better professionally clean this or they're going to ding my security deposit and I don't go to court. Aren't you using the security deposit to get me to do something I wouldn't otherwise have to do?
That could be true, Your Honor, if the facts were different. In this case, we have two plaintiffs who testified that they didn't spend any time looking at this provision, and they certainly they did not have their apartments professionally cleaned, and they didn't feel like they were required to have them professionally cleaned. So if we had a different factual record, that might be true, Your Honor, but I don't see it on this record.
Why is this a fact-specific question? I mean, your brief, I think, at one point literally says the purpose of this provision is to educate tenants about the conditions that they need to keep their places in. Is that correct?
Correct. I think the two
So
purposes.
isn't that essentially leveraging? Like we are telling tenants, you need to do this or else?
And I didn't use the word extorting, I used leveraging.
Well, I think there's two purposes to this provision and this move-out addendum. The one is I think it does provide estimates, and that is actually required under 15b(4)(3). So it provides some estimate of what the cost of replacement for some things that were damaged would cost.
Isn't it an estimate of the cost of remediating reasonable wear and tear in some instances?
I don't think that's correct, Your Honor, again, because I don't think you can, going back to one of the questions that was posed before, this is a little different from some of the clauses that exist, for example, in the Tatuli case, which was referenced in the Community Agency of Somerville brief, the Cass brief. That was a Justice Krupp decision, and there are a couple decisions in other state courts where they've tried to reconcile these two things. This provision does not condition the cleaning on a deduction from the security deposit, or condition a deduction from the security deposit, I'll put it the other way, on a cleaning. It says nothing about 15B. So to my mind, the simplest reading of this is that you could read this together with 15B.
Well, then can you
with
address then paragraph 35 of the actual lease, which is not the addendum, when it says you must follow move-out cleaning instructions, which are incorporated by reference, if they have been provided. If you don't clean adequately, you'll be liable for reasonable cleaning charges, which shall be deemed property damage.
I would say that there's nothing there that should be read to override 15B in the same way that paragraph 37.
So when it says shall be liable for, you think that that means we can sue you in court, not we will take it out of the security deposit?
That's correct, and that's
But
in the
then
same
you
way
vi-
that would be the fairest reading of the addendum to sort of.
But then you violated it by taking it out of the security deposit then. Then you, with at least one of these tenants, if that's the case, you clearly violated the statute because you took it out of the security deposit. If you're saying you can't do it, but you did do it. Right?
It has been taken out of the security deposit.
Right.
There's a factual dispute as to whether that was for damage beyond reasonable wear and tear.
Did you itemize it?
It was itemized in the form of the addendum, but we haven't gotten to that, Your Honor. That's for the trial court to decide whether it was itemized.
But if you require them to professionally clean, that is certainly going to be requiring them to pay for some ordinary wear and tear, reasonable wear and tear. It absolutely is going to make them pay for something that you should be paying for, right? Because it's clearly some of it is something you should be doing and not them, right? If you take that out of the security deposit.
If you take it out of the security deposit, absolutely. I mean, the only other interesting fact here, well, I shouldn't say the only other, but at the very end of Addendum 1, I believe this is on 241, there was a charge for professional cleaning. There's a receipt for professional cleaning for $100 for Ms. Peebles that was not passed along to Ms. Peebles. It's not in the SOTA, the so-called statement of deposit at move-out. It's not in that itemized list. So cleaning can be.
Doubtless, the landlord can choose not to charge a tenant for certain things, but can you articulate to me your view of the relationship between 15B6 and 15B8, and in particular, what is the difference between, in this context, between a lease that merely is inconsistent with the security deposit statute and one that affirmatively is obtaining from the tenant a waiver of their rights under the security deposit statute, such that the landlord under provision 6 is not permitted to take anything out of the security deposit. The statute provides essentially a remedy for tenants over and above.
It's a tricky question, Your Honor. They both talk about provisions of a lease that conflict with the security deposit statute, but 15B6C goes further because it essentially requires both, it additionally requires an enforcement of that provision or a waiver, a forced waiver.
It's an
upon
attempt
a
to seek
tenant.
a waiver.
That's
So I
right.
think to me that means a provision in a lease saying you shall be liable for reasonable wear and tear. You would agree that that is a waiver that would mean, do you think that's a waiver?
I think it would be a waiver of your security deposit rights if you had an express conditioning of the cleaning requirement, whatever we're going to call something like this, connected to the security deposit, as opposed to sitting here like this, where you could read it to mean it could be taken outside of the security deposit. So I don't view it as a waiver. Yes, Your
Opposing
Honor?
counsel talks about the word applied in the addendum. What else would it be applied to?
Well, I think I would read that as it could be applied to a charge that was brought by the landlord for breach of contract outside of the context of the security deposit statute.
No, that would be your damages for breach of contract. What are you applying to? That doesn't make any sense to me. If you sue the tenant for breach of contract, you get damages, and that may or may not be the professional cleaning fee. But in the addendum, it specifically says that these charges shall be applied to what?
They would be applied to the damages.
Okay, that makes sense to you.
It makes sense to me. I understand the argument that you could say they're applied to the security deposit.
Well, the
but-
only money that the landlord is holding to apply any sort of damages to the apartment is the security deposit. That's the only money that the landlord is holding of the tenants for which something can be applied.
It's correct that that's the only money that they're holding. I just think you could read that word applied in a different way. Again, the idea would be to read, unless this did, complete violence to the security deposit statute, would be to read these two things consistently. That's the basis of our argument.
But I'm confused then. So how do you want us to answer the second question then? The second question, if we think that that professional cleaning definitely includes some costs that are reasonable wear and tear, and you're requiring them to do that, how do we answer the second question?
I think the way that you would want to answer it would be that to the extent that a landlord wishes to contract for anything, including damages that would be within reasonable wear and tear, that would need to be done in a separate action outside of the context of a security deposit deduction.
So the professional, again, the question the judge asks us, I'm just looking at it, is when a tenant vacates the premises at the end of the lease, under what circumstances, any does charging him for painting, carpet repair, or similar refer to constitute, oh no, that's the first question, sorry. The second question is, does inclusion or provision of the lease requiring a tenant to have the premises professionally cleaned at the end of the lease or bear the cost of later repair constitute a violation of JLC blank blank? Is the answer to that yes, if it allows for a deduction from the security deposit? Is that how we?
Correct,
answer?
Your Honor.
Okay, so that's how we would answer question two.
That's right.
But okay,
Something odd struck me about the formulation of question 2, and perhaps you can shed some light on this. Do you know why it doesn't include any reference to the second sentence in the addendum? It seems to only focus on the first sentence of the addendum.
You mean sort of the or else part of
Well, the first sentence says resident is required to have the apartment professionally cleaned and carpet cleaned upon move out. That seems to be where Judge Gorton stopped his question. But there's a consequence that's laid out in the next sentence that he's omitted from his question. Can you shed any light on why that piece wasn't included?
I cannot shed any light. There just so the court's clear, there was no argument on either. This came out of a motion, competing motions for summary judgment, and then also a motion for class certification and our opposition there too. There was no argument that was held on either of those motions, and this just came, as an order, 2-page order without argument. So,
Well, it seems to me like the second question is actually indispensable. The second sentence is actually indispensable to answering the second question. Do you agree with that?
I agree with that, and I think if you were to combine it with what Justice Kafka said, you can get to that place, because I think
Yeah,
the
I mean, I don't see
formulation
how
talking
you
about would
can.
include that sort of, because it's an if-then clause, right?
Yes.
And we need the then.
It's a
I understand that.
consequence. And then, can I ask you one further question about the second sentence?
Yeah.
It refers to this condition. I can't really see a way to read the words "this condition" without referring it back to professionally cleaned and carpet cleaned upon move out. Do you agree with that reading?
I think the best reading of this condition is in relation to that professional cleaned and carpet cleaned
carpet
standard.
cleaned, yes.
And we view that as,
All
sort
right.
of cleanliness standard.
All right. Thank you. Oh, and one further question. It identifies the following, a chart, a little table of following charges, and it uses the word "will be applied," which is, mandatory language. And yet, there's been no briefing on whether the table is automatically, the way this reads, it sounds like the charges identified in the table are to be automatically applied. And yet, on the facts that we have, which are very limited, it doesn't seem that that's been the case. What are we to make of that?
Well, we know enough to know that the charges in the chart, at least with respect to the two named plaintiffs in this case, were not automatically applied. They certainly weren't applied to Mr. Berger. He didn't receive any damages related to deductions. And the charges that were applied to Ms. Peebles were actually less than any of the ones that were stated here. So it's a bit curious factually, but there's certainly no record that suggests that there was an automatic application of any, charges, cleaning, painting, refurbishment, whatever, for either tenant.
So the piece that troubles me about this is if we're to look at whether this provision violates the statute, it seems to me that are you arguing that we would need to look at it case by case as to how it was applied with respect to any tenant? That doesn't seem to me like that could be correct. It seems to me that as a matter of interpreting the statute, we need to look at this provision as it was written on its face and then determine whether, regardless of how the landlord decided to apply it with respect to any particular tenant, whether it does or does not violate the statute. Does that seem right to you?
I think that's correct. I think the application should probably be done after the fact by the trial court, whether that's on an individual basis or something else. I think the question can be answered. I'm not again, I don't think either of these questions is perfectly formulated for reasons that have been discussed, but I think this one could be properly formulated, and you wouldn't have to answer it in application.
Right,
because then you bleed into question one, which is a facts and circumstances.
And I feel like we're trying, when we start getting into facts and circumstances, it's as though the parties or the judge or whoever is trying to suck us into actually questions that should be left for class certification. And I'm leery of that, to be frank.
I'm leery of that as well, in the sense that there hasn't, the fundamental problem with this, I think some of these certified questions, is that they come out of a trial that never happened. All of the housing court cases that we cite, whether they go one way or they go the other, and they're very instructive, they're sort of a long recitation of, was this beyond reasonable wear and tear, was this not beyond reasonable wear and tear? That never happened in this case, so we don't have that record.
Okay.
If there are no further questions, thank you very much, Your Honors.